Good evening, this is Rahul Reddy. We're live from Houston, Texas. We bring in every week Tuesday at 5 p.m. Central Time, the immigration updates. Emily, what do we have today?
All right, today we wanted to talk about the idea of what happens in a recession, specifically for immigrants, high-skilled immigrants, employment-based immigrants. We've been through this before, and not that we're expecting an impending recession, but with all this talk of the coronavirus and things happening with oil prices, there are things that you can plan ahead and think about and just have in the back of your mind so that if it does actually happen, you'll already know what to do and have a plan in place. So we want to talk about that. We also want to talk about some recent information that came out from a Freedom of Information Act request that provided us with the amount of money that USCIS is receiving for premium processing filing fees. And we're coming to the conclusion about why there's so much delay in processing I-129 petitions and I-140 petitions, and what the premium processing fees means to all of that. We talk a lot about consular processing and the DS-160, so again, we want to reiterate some tips for properly completing that process at the consulate. And one of the common questions that we're getting right now is, once this whole H-1B lottery registration is going on and you find out on March 31st that you've been selected, at what point can you change your employer? We're getting a lot of questions about transferring the H-1B at various points in the lottery process.
Emily, on the recession thing, what I want to discuss about, I've been in recession process 2 times as an immigration lawyer. As was in a recession, the previous recession at the time when, the old Bush administration is gone, I mean, the senior Bush administration is gone. I entered, it was just coming out of the recession. Things were very dull, the salaries were very low, the offers of the H-1Bs, immigration offers were very low. Then I've also lived through the 2000 and 2001 as an immigration lawyer, and also I've lived through 2008 and 9, you were there too, in our office at that point of time. One thing is that the offers of the employment will be very low. We have seen a lot of unemployment at the time. The unemployment will hit very much on the H-1B immigrants. On the L-1 immigrants, most probably their extensions will not be done, their jobs will be terminated, and they need to plan ahead of it. Some of the people in 2008 and 9, they have converted into F-1 visa, which used to take only like 2 to 3 months. Nowadays, F-1 visa is taking approximately about 8 to 18 months. And they have to maintain the legal status in United States. And I don't see that it's possible to change the F-1 visa because they can't maintain the legal status on until the F-1 is approved. We also noticed that people move back to their home country and they want to come back after when the things turn around, when the economy turns around. People need to plan around. One thing is that if you've been counted towards the H-1B number and you have not used up the 6 years, you can always go to your home country, and when the things turn around, when you get an offer, you can come back on H-1B. For the L-1 visa holders, if they don't have a job offer, they need to leave the country, and once they leave, they can always come back when the things turn around. And there is no visa numbers for them, so they should always be good, so there should not be any problem for them to come back. There's no time limit. For those people who have completed the 6 years of H-1B, if the I-140 has been approved and it's not been withdrawn for a period of 180 days, I mean, there is no quota for you. You can always come back into the country. However, I want you guys to be financially prepared what to do, what not to do when you are going to get laid off and that things are in recession. You don't get a lot of job offers. For example, I will tell you what happened in April of 2018. Let's say we filed 100 H-1Bs in the new quota. When it comes to the April of 2019, we only file like less than 10. I mean, I would say about less than 10. It's about less than 10% of the H-1B, or even very close to 5% of the H-1B is what we have filed in 2008. We filed in 2009. So that tells that the offerings of the jobs will be gone, extensions will be gone. So you need to prepare what is going to happen with your home, what is going to happen with your car, how the kids' education is going to be turned out, I want you to sit down with your family, to discuss with your wife or your husband, to run around. What will happen? What are we going to do if we lose a job? If we both lose a job, what are we going to do? If one person loses a job, can we convert into H4? So those are the options that you need to discuss, have a plan ahead of it. The good part about it is that there is a 60-day grace period that was not there before. For the H1s and L1s, if you lose the job, you can still stick around in the country for a period of 60 days and try to pack your bags or arrange your things before you leave the country. You may want to consider discussing with your spouse right now, what are we going to do at that point of time? How are we going to get rid of the car, house, kids' education, transportation, any things that you want to take? What are we going to do with the furniture? I would want you to discuss with yourself, with your family, and also maybe a couple of your other family friends to sit down together. Let's have a discussion for 15 minutes. What are we going to do? And exchange the ideas might be a good idea for you. Emily, any?
Yeah, so make sure with that 60-day grace period, if you are relying on that, it has to be, your I-94 has to be valid for at least 60 days beyond when the job termination occurs. So if your I-94 is expiring before 60 days, then you only get the amount of time to get to the I-94 expiration date. So just remember that you do have the option of not being counted in the lottery for H-1B. If you do leave and you haven't used up your 6 years, you are considered cap exempt and can have any employer file a petition for you in the future without going through the lottery again. I think a lot of people are not aware of that and think that you have to go through the lottery again once you leave the country. So that's important to know. All right, on this premium processing, so this Freedom of Information Act request found that USCIS received $400 million in premium processing fees. And so what does that tell us about the processing times for regular processing?
Well, they are supposed to adjudicate the H-1B applications in 30 days only. They are supposed to adjudicate the H-4 applications in 30 days. They are supposed to adjudicate all the non-immigrant visa applications in 30 days, but they are not doing it. I think the reason is that they're making about $400 million every year, but not doing in the 30 days. You may say that they don't have enough staff. Who is telling them not to hire enough staff? Sometimes they don't have enough money. Well, they fixed the fees for the filing fees. They said it's a sufficient fees, and they have given the timing in the OMB office that they're going to take X amount of time to adjudicate the H-1B, approximately 12 to 18 minutes to adjudicate the H-4, but they're going to take it in a year or so. I think so the main incentive is for them because we're paying them the premium processing fees they're getting used to. I know the litigation lawyer, especially Jonathan Waston, who is an advisor for us, and he's been telling you should stop paying the premium processing fee and start suing the USCIS. It'll be cheaper to sue the USCIS rate rather than going to premium processing. It becomes tempting. We need to put a brake on USCIS one day or another. They're just making money and delaying everything, and the delay is causing a significant for H4s, H1s, and L1s. EB1C cases are taking 2 years nowadays, Emily, and there's no premium processing for that actually. But HS, Healths, OSPs, Qs, and they're taking a long period of time. The intention seems to be that delaying the justice is denying the justice. And these immigrants are not going to fight back in the court. They're not going to take them to the federal court, and that's the reason why they're doing this. But things are turning around. We got a good decision today from the USCIS. We got a good decision from the court today from Washington, D.C. That they can't use the February 8th memo, and then they should stop approving for short term. They should approve for 3 years. So that's very good news that we got from the Washington, D.C. Court today, actually. Going forward, I think so that people need to try to look into if in a delay, they should start suing USCIS, and that's the only way to get around.
Right. I mean, when processing times are more than 6 months normally, and you can only file 6 months in advance at the earliest, you're forced pretty much every single time you're filing
to lose
do
the job,
premium processing or lose your job or face the possibility of your processing going beyond when your current I-94 expires and then gets denied. You have very little options at that point. So premium has definitely, I mean, we've been a fan of it in that it provides a useful benefit for someone in that situation because the processing times are so long, but at the same time, we have to use premium processing because the processing times are so long, and they're just using these, purposefully delaying the processing to force more and more people to choose premium processing because they can make more money that way.
Yeah.
So it might be time for us to stand up and say, no, we're not going to be paying premium processing to get the result that we should be getting in 30 days with regular processing, and going to the court instead of paying that fee going forward.
Emily, we have seen a lot of 221Gs and visa rejections. Is there any things that you suggest where you feel that as an immigration lawyer, the clients can correct themselves before going to the consulate, things that they can avoid easily?
Yeah, I think the top thing is being very careful about filling out the DS-160 visa application. Ever since that application has gone online, you have to imagine that the consulate has a record of what you've submitted in the past and what you're submitting now, and they can cross-check with information that USCIS has, the Department of State has, CBP has. It's all electronically available, and it makes it very easy for them to spot discrepancies, and they can use those discrepancies to claim that you misrepresented something. And misrepresentation is a ground of inadmissibility, meaning they can deny your visa because of misrepresentation. So accurately filling out the DS-160 is probably the top thing. Reviewing everything that's already been submitted and reviewing your application before you're filling out the DS-160 so that you can make sure that what you're filling out is consistent with what has already been submitted to USCIS on your behalf would be another top thing to look at.
One thing that I want everybody, when they go for a visa application, to read the petition. Read the petition 3 times, please, especially the employer letter. The I-129, if you're for a non-immigrant visa, which has an I-129, read the I-129 and the employer letter and any additional documents that are there. Please read it. A lot of times what you think is the position may not be in the same line of what the employer might be thinking, what the documentation might be there. If you think that position is X and maybe the document says X, your position is Y or the job is Y and you have any disagreement, yeah, call up your employer. I don't think so, it's X position. The employer might have say, no, I hired you for Y position. So have a debate with your employer, have a debate with your employer's lawyer that this is incorrect. Don't go and debate with the consulate. I'm sure you're going to get the denial. So I see the most common mistake they do is that they don't read the petition, they just imagine themselves what the position is and go. A lot of times, when people read a book, each person gets a different idea. I mean, if you don't even read the book, you will have any crazy ideas. Now, in this case, if you read the petition, though, you will be pretty much aware of what the things are. Will be aware. If you don't read it, you'll be in trouble. That's the most common mistake that I think so that I do. And don't try to omit any information. We have seen people omitting the university's experiences. That's going to come back and hunt you because if there are, as Emily has pointed out, it could be misrepresentation. If you omit any of the experience and you want to cite that experience at a later date, though, that is going to become a problem when you come into the United States. Oh, do I need to list this one out? I don't need to. And then you later list, it's going to be a contradiction for the DS-160 to that of the labor certification, H-1B or any other form. It's going to become a problem. So please make sure that you list everything what you are supposed to. Emily, now H-1B is lottery in full fledged. People are applying for the lottery system. It seems to be much easier than what we initially thought. Initially, the first day we said there are a lot of glitches. Seems to be that glitches are going out right now. Things are getting filed right now. What if, after the lottery is over and I get selected in the lottery, can I change to a different employer? Can I use this employer lottery and file with another person?
No. So the lottery, when you get that electronic registration confirming you've been selected, that document has to be submitted with the petition that's filed only by that employer. So you are only able to file a petition with the employer that submitted the registration on your behalf. Now, what if you file that petition and then you want to switch employers? Well, you still can't switch employers while the petition is pending because even though you've been selected in the lottery, you're not actually considered to be counted in the cap until you've been selected and you've been approved and you've crossed October 1st. So if you were to attempt to file a transfer based on your pending selection petition, that transfer is not going to be approved. Even if your lottery petition has already been approved, if you haven't crossed October 1st yet, you may not be able to transfer that because you haven't been counted until the H-1B actually kicks in. So really the ability to transfer a selection to a different employer is not an option until you're approved and October 1st comes.
Let's go to the questions, Emily. Mr. Iyer has this question from YouTube that will corona virus will bring the backlog because our rest of the nation, rest of the world will not be that much people there. I hope, Mr. Iyer, that this coronavirus is not going to be disastrous. At this point of time, the death rate seems to be about 1 in 25. Hopefully, we have doctors, medicals. They are improving on it. Hopefully, they'll find a solution for it. But at this point of time, I don't think so. Because of that, the priority date will come to a better stage for Indian nationals just for that. I hope the Senate 386 bill gets passed, and that's the best solution for you guys.
Raj from YouTube wants to know, after he received his first H-1B stamp in his home country, is it possible to apply for the next stamp in Canada or Mexico? Are there less chances of getting a 221G in that situation? So yes, once you have received your first visa stamp in your home country, in general, you should be eligible to apply for the next stamp as long as it's in the same category. So if you received an H-1B visa stamp in your home country, let's say India, and now you want to apply for the new H-1B stamp in Canada or Mexico, that is allowed. You can do that as a third country national. And we've seen a lot of smooth processing for individuals that have done both H1 and L1 stamping in Canada and Mexico in recent months. There still is a chance of 221G, especially if you're coming to the consulate unprepared, you haven't read through the petition, if you're in third-party placement and you didn't bring a end client letter or the contract or able to answer questions about employer-employee relationship. Those things can all trigger 221G administrative processing, even in Canada or Mexico. So be prepared is the best thing you can do for your visa interview. Be very knowledgeable about what's been filed on your behalf. And we've had a lot of good success in Mexico or Canada lately.
Srinivas from YouTube has this question that he got in, his wife's H-1B got denied, and it was denied for the specialty occupation. Now another company is going to file an H-1B. Will it going to cause any problem because the previous H-1B has been denied? No, it should not cause any problem just because previously it was denied from a different company. If it is denied from the same company and the same company is going to file the application, the officer may look into the old petition to draw any of the suggestions from the old denial. It will not be a conclusive thing that they are going to deny the second application. They're going to look into the previous denial, but as such, it's not illegal to file one more H-1B application when the previous H-1B application has been denied. It's nothing illegal that you are doing, even if it's the same company.
Sandy from YouTube wants to know if you get a new I-94 number after using automatic visa revalidation to re-enter the country. So if you are re-entering by air, yes, you do get a new I-94 number. You print that out from the CBP website after you land. As far as if you are driving, there's a chance that you might not get another I-94. Sometimes they just let you in and have you use the same one. We see that from time to time, specifically when you're driving. So if you are trying, if your purpose of the revalidation is to get a new I-94, you might want to choose air travel to ensure that happens.
Kalyan has this question: what is the exact 180 days after the I-140 is approved? Is it the notice date present on the I-140 approval? Yes, it is the notice date. It will be on the left side of the I-140 application. And on the left side of the I-140 application, there is a receipt date and a notice date. It is a notice date that counts as 180 days. It's not the receipt, it's the approval date, which normally is the notice date. That's how they put it, as a notice date.
Raj from YouTube wants to know if you made an error in the DS-160 in the past, can you fix it now, or what should you do with future DS-160s?
Wow.
So great question. You're not able to fix an error on an old or previously submitted DS-160. So if you're talking when you went for your visa interview 3 years ago, you had something incorrect in the DS-160, you can't go back and change that now. All you can do is going forward, make sure you do put the correct information. Now, if the discrepancy is something that would have been material for the officer to know during the interview, you may want to discuss with an immigration attorney before you submit a new DS-160 or before you make travel plans to go for stamping again, to understand how much of a risk there is by going for stamping now with that discrepancy in the past.
Ajay Mishra has this question. If two companies file two H-1Bs for the same individual, and if they get picked up, what will be the problem? The first thing, Ajay, is that today, actually, in the court, USCIS submitted a response to the court litigation that the way the USCIS is doing the lottery system, it's encouraging the fraudulent filing of the H-1B. In response to that, USCIS lawyer did presented and said that they have all systems ready to prosecute when there is no genuine job opportunity. They are going to prosecute the duplicate application files. My simple theory is don't file for the duplicate. We're expecting a lot of fraudulent filing this time. The USCIS is ready and they want to throw people out. Don't give them an occasion to throw them out.
All right, we have a couple of questions, one from Facebook and one from YouTube, about the idea of an H-1B extension being denied. What are the options and how quickly do you have to leave the country? So in the event of an extension denial, it depends, number one, on whether the previous petition has expired yet or not. So let's say that you filed your extension early, more close to the 6-month mark, and you used premium processing, and after a month there was a request for evidence responded to, and then you got a denial, but your current petition is still valid for another 4 or 5 months. In that situation, if you can overcome the grounds of denial, you can remain in the country based on your currently approved petition and then refile the extension with new documentation with changes to how it was filed to overcome the grounds of denial. You also have the option of filing a transfer if your previous petition has not yet expired. Or you could file a change of status to any other type of visa that you qualify for because you filed early and you got the decision before your change of status, before your previous extension had expired. The answer is much different if your I-94 has already expired from your previous approval and now you get the extension denied. At that point, the options are very limited because the denial, not only does it put you out of status, but from the day after the denial notice, you are accruing unlawful presence because you've overstayed your I-94. If you accrue 180 days of unlawful presence, before you leave the country, you're going to have a 3-year bar to being able to get a new visa. So it's very dangerous for you to stay beyond the time of that denial notice when your I-94 is already expired. And be aware, if your spouse application was also pending based on that, if you had an I-539 and that I-539 was also denied and the I-94 has expired, you have to be aware of the NTA memo that says USCIS can issue a notice to appear for your spouse in deportation proceedings if you stay more than 30 days after the denial notice. So that provision right there is not yet applied to I-129s, but it does apply to I-539s and I-485s if a denial occurs when your I-94 has expired. So be very careful of that. Make sure you understand what the repercussions are of staying if you receive a denial after your I-94 has expired.
SS has this question from YouTube. If he has been on H-1B and he spent 6 months outside United States in India working, and then he comes back, will that 6 months period that he spent in India be counted towards the 6-year period? He was actually working from India at that time for the same company which filed the H-1B. Here is the law that it's the physical presence that counts, not the work. You may be working for 10 years, out of which 5 years was in India. That doesn't count. The only period that counts for the 6 years is the physical presence that you were here in the United States on H-1B. That's all it counts.
Ankit from YouTube has a STEM extension that's expiring in March of 2021, and he wants to know what happens if his H-1B registration is not selected this year. Will he be able to file in next year's lottery? So that's kind of tough, because the technical answer is yes, the employer can file again for you next year, even though your STEM OPT is expiring in March. However, you won't have a way to remain in the country while that process is going on, unless you get selected and you file the petition during your 60-day grace period. So that would be by May 21st. That would give you the cap-gap extension, but that cap-gap extension only applies to your status. It extends your F1 stay. It does not extend your employment authorization. So that can be very tough to have an employer sponsor you next year in the lottery if you're not able to work for them through October 1st. So it can be done, but from a practical standpoint, it might be difficult to convince an employer to do that if you can't work for them.
Bhaskar's friend has worked for 15 days beyond I-94 expiration L2 EAD, and the person got paid, and that friend is worried that it's going to cause any problem. Will it impact his extension? I would recommend your friend to contact a lawyer, but I would say that if it's a 15 days, an innocent transgression, there are ways around it which may not impact wholly on your legal status in the future. But there are steps that need to be taken to rectify that 15 days. They should contact the lawyer.
Ram wanted some information about which SOC code is more applicable to a particular position. So the SOC code is the Standard Occupational Classification. That is the general occupation category that has to be listed on each LCA. So if you're filing an H-1B, you need an LCA, and on that LCA, the person that's completing the LCA will usually determine, either the attorney or the employer and attorney together will decide what occupation category your particular job falls under. That occupation category is then important for determining what prevailing wage applies, and also it becomes an issue for USCIS later when you file for determining whether that position qualifies as a specialty occupation. Now, how to pick between two codes, that all is going to boil down to the job duties. They don't look at the title. USCIS looks at the job duties for the position, and they look at the job duties that appear for that occupation code, that SOC code, in the ONET online system. So you go to ONET, you look up the code, it gives you a very detailed information about what the typical job duties are for that occupation code. Then you look side by side how much of your job duties line up with that code. Is one code a better fit than the other one? And you make the decision based on which code most fits your particular job duties. So it's not based on title alone, it's based on job duties. And then you want to look at, once you select that code, look at the Occupational Outlook Handbook to see what it says about what the education requirement is for that position, to make sure you're not going to have an issue with qualifying for specialty occupation.
Mohammed has this question that once he gets the green card, can he immediately change the job? Will it have any negative impact? The answer to your question, Mohammed, is no. I have not seen any problem whatsoever at all. Once you get a green card, based on the employment base, if you change the job, it's not going to cause any problem. Anya from from Facebook has this question: will the H-1B extension be delayed because of the coronavirus care? I don't think so any of the people who are adjudicating your H-1B is caring for coronavirus. So they shouldn't be delaying it, but that's my opinion. But USCIS can delay for any reason, and they can state any reason. You know, that's how they are. I mean, when I last went to the service centers, they don't even work from the service center. They take their work to home and work. They come only like every 10 days or 15 days there to drop or pick up those files. At the most, they come once a week, stay 1 hour or 2 hours in the office, and then go and work. I said, why are these people not working in the USCIS office? There was no corona at the time when I visited. They said that we don't have enough space, we're saving the energy, money, so that they can work at home. So most of the officers are working from home. That shouldn't affect though. However, based on how the USCIS is, they will try to make any excuses because of their inability to act.
Let's see, we had a question about the H-1B registration process. Who actually creates this registration? Is it the employee or the employer? So the employer must create their own MyUSCIS account as an H-1B registrant, and then either the employer or the attorney will use that account to create an H-1B registration form. If it's an attorney that does it, they then send a code to the employer so the two accounts can be linked together, and then the employer approves the G28 and registration and then pays the fee. So it's all done by the employer and the attorney, no action at all from the employee.
Swaroop from YouTube has this question. He's filing the H1 and H4 and EAD. His H1B is expiring in 5 months, and the H4 and EAD are also expiring in 5 months. Will he get the EAD and H4 in 5 months? Most probably not, Swaroop. That's the reason why Reddy Neumann PC takes approximately around 50 people to court every other week, and we sue the USCIS to get the approval. The whole process might take about 3 months with us from the time you file an application. I want you to contact us immediately as soon as your premium processing for the H-1B has been approved. One question, if you're filing in the normal processing, forget about it. The whole thing will be taking a long time. Even in the normal processing, they're not adjudicating the H1, H4 and EAD together. So it's strongly advisable if your wife is working to have you file a premium processing, then join your wife join the litigation, court litigation, where she goes to the federal court and we take to the federal court and get your things approved. Otherwise, it's going to take a long time. If you're going in normal processing and there is an RFE, you're speaking about 8 plus maybe even 8 more months, 16 months to get it.
Rajarshi from YouTube is currently on L1, but has a previous H-1B approval from back in the 2018 lottery. Never got the H-1 stamp using that approval notice, so he wants to know if he can use this H-1B approval to file with any other company. Unfortunately, no, because I'm assuming that H-1B in 2018 was filed requesting consular processing, not a change of status, so that when you got that approval, it did not have a new I-94 on it. So in that case, if you did not get the visa stamp, you're still not considered counted in the cap. You cannot use that to transfer to another employer since you're not counted yet.
Chaitra has this question. She hired an attorney for H-1B, but the manager says attorney is not required for LC and H-1B application. Is it true? Just curious. Well, Chaitra, it's not absolutely needed for an LCA H-1B, your lawyer, but we would strongly suggest that you pick a lawyer to file for the LC and H-1B. However, the choice whether or not to have a lawyer or not will be made by your company. It cannot be made by you, only your company can make it. Now, is it required when somebody has been accused of a murder case to have a lawyer? It's not legally required, but of course it's strongly recommended that they do hire a lawyer. And the same case is nowadays with 25% H-1B denials, it's better to hire a lawyer. But it will be your employer who will make the call, not you. Vidyulata from Facebook has this question. Vidyulata's husband Naresh has a question on the Facebook that his wife is in India, he's going for H-1B stamping. Can he file for a H-4 EAD? Does it impact the H-4 stamping? First thing, Mr. Naresh, Vidyartha's husband, I guess, is that if your wife is not in United States, you cannot file for the H-4 EAD. She has to be here in the country. Once she's in the country, once you file the EAD, she can leave the country, that's fine. I'm speaking of only about H-4 EAD right now.
Naveen from YouTube wants to know our opinion on the Forbes article regarding the recent federal court case with the decision where they basically slammed USCIS for improperly denying H-1B petitions on the ground that it was not a specialty occupation. So yeah, more and more employers and their attorneys are turning to the courts to overcome these ridiculous H-1B denials. It's not a great option anymore to file an appeal with the Administrative Appeals Office. It takes way too long, and it doesn't provide you with any status while you're waiting. You can get a much faster result by going to federal court litigation. And more we are seeing these judges that find that the decisions made by USCIS are completely arbitrary. They're not in accordance with the law. And now we're starting to see that they're questioning some of the policy memos that USCIS has put out in the past without going through the notice and comment period, because there are changes in interpretation, and now they're saying the agency is not going to be given deference to make this kind of changed interpretation unless it actually goes through the regulatory process.
That was Brad's case in Forbes. Of course, there's another case that Brad, I was speaking with him recently, that came out today. Actually, that's more drastic than the Forbes case, Forbes article that you're reading, which will be published very soon. This is slamming the USCIS, going to, as Emily pointed out, as taking all the memos saying that they are not legal and they should not be applied. That decision came out today. You'll see an article pretty soon on that.
Praveen from Facebook says, now that spring is here, do we have any update on the H-4 EAD? That's a good question, because we've been following this H-4 EAD regulation where we know the Trump administration is determined to eliminate the H-4 EAD. It was thought that it would be done through litigation. Then during the litigation, they said, no, we're going to do this through regulation, and we're going to issue a regulation soon. Soon came and went, and no new regulation. And then finally, the last update was spring of 2020 is the earliest we might see a proposed regulation. Well, here we are in spring of 2020, and there's still no proposed regulation. So before that can actually be published, it does have to clear the OMB. I have not checked it recently, but my guess is I would have heard about it if it had cleared the OMB. So I think it's still the same as before. It could be months before we see a proposed regulation. I mean, really, we've been talking about having a proposed regulation for what, 2 years now?
Yep.
And still nothing?
Let's not poke them.
Yeah, exactly. Let's just let them take their time on that.
Sripad from Facebook has this question. He has 2 different employers filing 2 different unrelated entries. Is that okay to file duplicate H-1Bs in the quota? The answer still is no. Sripad, about 1 week ago, I think so, 3 employers went to jail, and all the H-1Bs that were filed by those companies got invalidated. So even if they have moved from that company to a different company, have been invalidated. That was a story in 2019 February to about 2020 February. Approximately around 40 to 50 employers were being criminally prosecuted for filing multiple applications, though. Now, is there a genuine job opportunity for the second job, though? That is very crucial, though. What will happen? They will look into how many other applications have been filed. Is there a genuine job opportunity there? 99% of the time when we are being hired by these companies, when they are prosecuted, it is very clear that there is no job opportunity. I mean, believe us, it is crime to cooperate with the people who are filing applications where the job does not exist. It's called conspiracy. You will also be punished for, although we have not seen many of the employees being persecuted for being cooperative with the employers to file a fraudulent applications. However, we have seen their H-1Bs getting revoked, even if they left the company and joined some other company. How many times have you seen that, Emily?
Oh, it's it's going back to 2016. They're revoking constantly. I mean, every week we get news,
new consultations.
on
People
it.
come in and say, "Oh, I got a notice of intent to revoke. What do I do?" Then we ask the question. When you file the H-1B, we go back into their company record. They filed it, and it's so easy to find out. In fact, I've seen an advertisement today in Great Andhra, Emily. And in there, they're advertising, we're going to file the duplicate H-1B, second H-1B application for you. I even went and checked their website. They have clients like Google and all the other companies. Guess what, where the company is located at? It doesn't even have an office location. It doesn't even have an office location. They're running it from an apartment or a home, and they're saying they have a Google, and they're filing this advertisement I saw on Great Andhra website. You can go check it out for us. It's on Great Andhra, and they're saying we're going to file. I mean, it's so clear. They don't have a job. Where? They don't have any clients. They're just filing it. This is a short-term thinking of the people to make the money. Some of these owners are not even here. They're operating from India. You are the guys who are going to get stuck. And we are also anticipating any of these people might be a sting operation. In other words, they will tell you that they're going to file it for you, and they're going to have you commit on the phone or on the email, and then you may be even deported. It happens with University of Farmington. They paid the agents, they paid these people to recruit the innocent Indians to come and join these things. Don't fall into the trap. All these multiple filings are all the time fault. 99.99% of the time, they're all fraudulent people. And don't fall into that in the multiple filings. You will be in trouble.
Joel from YouTube recently got a second H-1B RFE and wants to know if that's common. So I wouldn't say that it's common, but it's not unheard of. It's more common nowadays than it was maybe 2, 3, 4, 5 years ago. So probably not last summer, but the summer before, we started seeing the wage level 1 RFEs. That's really the first time we started seeing consistent second RFEs on H-1B petitions. Prior to that, I would say in the last 15 years, I'd seen maybe 1 or 2 cases total. And now it is more and more common. So it doesn't necessarily mean there's something wrong. It's just, you may have an officer that didn't catch all of the issues in the first one, or the response that they received back raised other issues, and now they have to issue a second one.
Prashant from YouTube has this question. The H-4 transfer denied because of fingerprints taken as per the FBI. I-94 expires on March 23rd. Shall we refile or go to India for stamping? H-1B is approved for it. First thing is that a H-4 a transfer application or an extension application? If it's an extension application, since we are not done with the March 23rd, you still have time, you can file an application. It was an H-4 transfer application. What visa she was before? Did she still maintain the visa status until today? If that's the case, you could file another transfer application right now. So I want to know which status that she was in before she does. Did she maintain the status? That's more important. This is a common thing that we are noticing about fingerprints. Because of the fingerprints, the USCIS is issuing the fingerprint notice. People are not going, and you might have not received it. There are ways you can still go to fingerprints, but in Prashant's case, he's telling that they didn't took the fingerprints properly. I mean, that is ridiculous. They should have called you for one more time for fingerprints if you have gone for the fingerprints and the fingerprints got rejected. But either way, please make sure if it's an extension and I-94 expiring March 23rd, 2020, I don't have a problem in you refiling before March 23rd.
Angie from YouTube wants to know if the public charge rule is applicable to parents that are visiting the U.S. on a tourist visa, B-2 visa. It's a good question. We've talked a lot about public charge. The changes to the public charge rule are more impacting on people who are in the U.S. and filing an extension or a change of status, those filing an I-129 or an I-539 application. That being said, the public charge rule has always been there for someone who's applying for a B-2 visa at the consulate. They always have to prove that they are not an intending immigrant, that they have a residence to return to, that they have the intention of only coming for visiting for pleasure or to see family, and that they will return at the end of their stay. And one of the grounds that they can be denied the visa on is if they are likely to become a public charge. That's always been the rule for B2 visa applications. What's different now is they look at more factors to determine when someone is going to be a public charge. And when you're applying at the consulate, if they suspect that your parents might become a public charge, there's a new form that they may ask them to fill out, the DS 5514, I believe, that asks a lot of financial background of them. I have not had anybody since February 24th that has gone for visa stamping that has been asked to fill out this new form, but it is a possibility.
Emily, I want to discuss with you on some of the things that I don't have answers now. In a scenario, coronavirus, the person has a job in LA. He lives in Atlanta right now, and he doesn't want to travel to LA. Does he need to file an amendment because he's in Atlanta right now?
Good question. So it depends. Generally, if you do not have an LCA that covers the work location, an amendment is required. So if your LCA only covers LA and it does not cover Atlanta, an amendment could be necessary to change your job location to Atlanta, unless you qualify under a specific exception to that rule called the short-term placement option. So in certain circumstances, you may be eligible to work from a different location that's not covered by the LCA for up to 30 days if the employer is meeting certain requirements. Those are very specific, so probably too much to go into now, but there's a really good fact sheet on those requirements on the Department of Labor website. If you look up H-1B short-term placement fact sheet, it'll take you right to it, and you can see what those requirements are to see if your situation might qualify under that provision.
Well, now another thing, what if it's 32 days I'm going to be staying in Atlanta, and both states, Georgia and California, declared emergency right now? Does the state emergencies will disqualify the federal law?
Definitely not, and because just because there's a state of emergency doesn't mean you don't have to comply with immigration laws, and it's easy to comply. File an amendment. You don't have to go anywhere to file an amendment. Everything can be done through the mail and online. Make sure you're complying. That would be the easy answer. Don't risk it. If you think it's going to be more than 30 days or that the short-term placement doesn't apply, either travel or file the amendment.
One question from Manish is that my H-1B extension got approved in 8 days, even though he did not file in premium processing. Is everything fine? It's an employer, vendor, and client situation. It's like, yeah, we have noticed some cases that got approved. We have also noticed in the I-140 some cases that got approved within a short period of time, even if it's not filed in premium processing. I don't see anything wrong. Some of the officers are very active. They're trying to comply with the law of 30 days. That's very good. And he complied with it. Salute that guy, and that's about it. You take the approval. Good for you.
Excuse me. Shanker from YouTube wants to know, he's planning on filing his H-1 renewal at the 180-day mark, which is the earliest you can file it, and he wants to file it in premium processing. He wants to know if the H-4 and EAD can also be filed at the 180-day mark, because the general rule is the EAD can only be filed at the 120-day mark. So if it is being filed along with an H-1B concurrently, yes, you can file it earlier than the 120-day mark. I mean, that's what we do for transfers. Many times when we file a transfer, the EAD is not expiring for some time, but we want to get the extended validity on the EAD to match the H-1B transfer approval. So we will file it even though the EAD is expiring more than 120 days from now, and no issues with that. Never had a problem.
Mahinder from YouTube has this question. He is transferring from company A to company B. He only have a receipt notice. His family has a valid visa stamping with a previous employer until December 31st, 2020. What does he need to do? How can he call his family? Your family can travel on the old visa, which is expiring on December 31st of 2020, even though that H4 visa is not issued for the company for which you are working. Since you're maintaining your visa status by working with the company B, absolutely no problem in your family coming into the United States on H4. I have this question for you, Emily, and Ravi Kiran from YouTube. What's your predictions on H1B lottery?
Oh goodness. I've really struggled this
You got to
year.
give a number.
I know I usually give a number, and I'm kind of scared to because it's just so different this year.
I'm standing at 320,000. Emily, where do you stand at?
Oh my goodness. Yeah, I was thinking 350.
Okay, let's see who wins the bet.
Yeah, I mean, with this, it's only $10. The registration is so simple. And, the unemployment rate is super low. We tend to see much higher filings in that situation. And then because of the way the lottery is being run, I think it's going to be much higher, probably the highest it's ever been.
But at the same time, we're expecting a lot of, once lottery has been done, they're going to prosecute or they're going to deny a lot of these lottery things and then probably issue more for the people in the next thing. So we're expecting a lot of fraud actions to deter the fraud action from USCIS also in this lottery system.
Vicky from YouTube has an H-1B expiring coming up in May, and things are going really slow with getting the extension filed. And so he wants to know if the extension is filed, can he continue to work on the H-1B receipt? What happens to the driver's license and all of those sorts of things? So you're right. I mean, we generally recommend filing the extension much earlier than what is happening here, but unfortunately it's kind of out of your control. As long as the extension is filed before your current I-94 expires, that extension puts you in a period of authorized stay and allows you to remain in the U.S. and work based on the pending extension even after the I-94 expires. That's valid for up to 240 days. The difficulty is with the driver's license renewal. Some states will not accept a receipt notice to renew your driver's license. So if you're in one of those states, you may have to Uber or take a taxi or see if you can work from home if that's allowed under your LCA and the petition, so that you can keep working during that time.
Well, this sir has this question that is it safe to travel on EAD and advance parole? In general, I have not seen much problems in people traveling on EAD and advance parole. Not, every 10,000, one case might have some specific issues that are in there, but in general, I have not seen any problem. I have not seen any risks involved in traveling on EAD and advance parole.
Nilesh from YouTube wants to know if he needs to go for another I-485 interview if he changes jobs while the 485 is pending and he's already done an interview. They could always call you in for a second interview. I don't think I've ever seen it happen. To change jobs at this point, you will have to submit a new I-485 Supplement J with your new employer to show that the new job is in the same or similar occupational category as the old job and that your 485 has been pending for at least 180 days. But generally, they do not interview a second time after you file that.
But make sure that you file a 485J supplement, that you inform the USCIS that you changed the job. It's absolutely essential, because if they find out that you're not working with the company, they may deny the 485 without giving you any notice. Anything else, Emily?
I think that's about it for today. Sorry if we weren't able to get to your questions. We try to get to as many as we can during the hour, but please know that you can also join one of our daily conference calls. If you didn't get your question answered, that's free. You can go to rnlawgroup.com to get the schedule and the dial-in information for that. We do it every day. And if you want more specific information for your circumstances, we do always recommend setting up a consultation with a qualified immigration attorney. You can do that with myself or Rahul or any of our attorneys here in our office by going to rnlawgroup.com and clicking on consultation. There you can see all of our schedules and schedule it online, and we'd be happy to help.
Thank you for joining.